Hey everyone, Harry here to talk about the Supreme Court's decision this morning in Alexander versus the NAACP, a South Carolina voting rights case. And it is a 6-3, the monolithic new conservative majority with a conservative result and a troubling one. So, after the 2020 census, South Carolina in a political process dominated by Republicans, who are the majority in the legislature, drew new maps. And the maps sure looked as if they were based on race, at least as a sort of proxy for Democratic voters, and they kind of ghettoized black voters in majority districts that minimized how many members of Congress they could have strong influence over the election of. And indeed, a 3-judge district court, that's how they work in these kinds of cases, found that race was the predominant factor. Now, that is, you're probably generally aware that in recent years, the court has really cut back on, you might say eviscerated, the Voting Rights Act. Section 5 is pretty much by the boards now, but Section 2 does retain a role for striking down maps that are done on the basis of race. But that role now is pretty substantially reduced because the thrust of the 6-3 opinion and the reversal of the unanimous 3-judge district court has to do with the kind of credit one gives to the legislators and what they say, and Alito's opinion for the courts. Its sort of operative principle is you must assume the good faith of the legislators, and therefore, good luck in finding you would really need some very vivid evidence of what would it even be is a bit of a puzzle, because if the proof of the pudding ought to be in the map. If they've drawn a map that's a wacky shape that is has it really puts all the black voters in the minimum number of districts to exercise influence over, what else would you need? But there is this kind of latent puzzle in what remains of the Voting Rights Act, that if you do it for partisan purposes as opposed to race purposes, that's okay. You're allowed to, or the court has said it's staying out of the business of and won't second guess partisan gerrymandering, but race-based it will, except now, if legislators come in and say, oh, no, it was for partisan reasons, not race reasons, the 6-member rock hard conservative majority is saying you have to credit the good faith and start there. So that really takes what's already the small measure of a little bit of an opening to review maps and sort of phase shifts it so it's all the more rare. And as Justice Kagan said, in dissent here, you've got a ruling from the district court. You shouldn't make it harder and put your thumb yet more on the scale. You shouldn't, rather than do that, you should respect the more than plausible findings of the district court that the state engaged in race-based districting, and tell it to redraw without targeting African American citizens. So, you look at it straight up and you don't put your thumb on the scale, and you find that it sure looks race-based, but they've brought in this sort of subjective test along with a presumption of good faith, which that means the Supreme Court would be in the business of actually, in order to strike something down, castigating, actually calling state legislators liars. And that's something you're not going to see the court do very much. So I think Richard Hassan, he's a colleague of mine at UCLA. He's an election law specialist. He says, Justice Alito for a court majority has once again come up with a legal framework that makes it easier for Republican states to engage in redistricting to help white Republicans maximize their political power. And that's just really true. I think it's unassailable, and it's because they've put in this extra padding cushion where you have to find bad faith. Now, this map that was struck down, but then the Supreme Court took the case and put a stay on it, and both parties urged them to rule by a few months ago in order that their ruling would apply going forward. They didn't. So this is one of the ones in which they've delayed to possibly the detriment of the principle in the country. In a sense, it doesn't matter because they've now come out and said that the map as drawn rather than the striking down by the district court, the map as drawn applies. It'll apply in future elections, since by their inaction, it already was the case that it was too late to change the map, and the district court, 3-judge district court, already had ruled, okay, for 2024, we're going to go with the ones that the Republican legislatures drew. Now going forward, even more so, that will be the case because the court has ruled. So it first delays and ensures that the Republican map that 3 judges had held is race-based illegal redistricting. They had already assured by inaction that it would apply to this election, and now they have held by 6-3 that it applies going forward. And in the process, altering Section 2 by saying, courts need to assume, start with the assumption of good faith. That is, when they're saying it's not race, we believe them, whatever the evidence in front of their eyes are. And that evidence has to be however strong it takes to overcome a presumption of good faith. So, I think we've got a few thumbs on the scale now in the voting rights area, and we certainly have in South Carolina this year and going forward a map that distinctly dilutes Democrat and African American voting power, but that the court is permitting to pass. Both because, previous provisions of the Voting Rights Act have been struck down, and because, whatever it looks like, they're saying you've got to presume good faith. And here that's enough to overcome what seemed like a strong case that the district court had found of race-based redistricting. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.